Oui, voilà,
merci. Ouais, c'est bon, merci. Tu veux quoi? Ah non, c'est moi qui veux. Ok. Bonjour à tous. On vient ici au nom de la LCS, donc la Law Career Start, une association des étudiants en droit, pour vous présenter un de nos événements liés au pôle workshop. Désolée pour ceux qui vont entendre la présentation 2 fois. On organise un procès fictif en MS 180 en 2 soirées, donc le 5 décembre et le 19 décembre. Et je te laisse.
Alors, je vais juste vous présenter un petit peu l'événement. Donc, ça sera une pièce de théâtre sur la pièce Les Justes d'Albert Camus. Donc, c'est un groupe de révolutionnaires qui prépare l'assassinat du grand-duc pour libérer le peuple. Et toute la thématique, ce sera sur peut-on tuer ou être tué au nom d'une cause juste. Et il y aura justement 6 plaideurs pour le lanceur de bombes et 3 à 4 jurés qui vont justement pratiquer le droit.
Donc ça, ce sera pour la première soirée le 5 décembre. Et ceux qui seront choisis en tant que finalistes, donc il y en aura 2, pourront participer à la finale du 19 décembre, où la même pièce de théâtre sera présentée. En fait, c'est les faits de l'accusation tournées en pièce de théâtre. Sauf que cette fois-ci, ce ne sera pas le lanceur de bombes qu'on accusera ou défendra, ce sera le groupe en lui-même, la participation du groupe. Donc la finale aura lieu le 19 décembre. Et on espère, mais ce n'est pas encore sûr, obtenir un coaching privé pour les 2 finalistes par les jurés qui sont des praticiens du droit. Donc si ça vous intéresse, vous pouvez scanner le QR code. Ça, c'est que pour les inscriptions de participation, donc pour plaider. Et vous avez jusqu'au 15 octobre. Et si jamais le texte de la pièce il sera connu à l'avance, et vous pourrez voir la pièce aussi, comme ça vous pouvez bien vous préparer. Merci.
Okay. Good morning, everyone. Let's get back to arbitration. Today sorry, just need to put this on. Okay. So today we continue with this question of the core concepts, principles, ideas, notions that you need to know in order to understand how arbitration works. And I'm going to focus more specifically on these 4 concepts, and after that, today we should have time for a little in-class quiz. So I'll be showing you questions, exam-type questions taken from earlier, from exams, I'm not sure they were taken, questions which are like the questions you'll have in the exam, and you'll be able to, using Votomatic, you'll be able to answer these questions, and then we'll briefly debrief. It's a way to sort of test your knowledge and to prepare you for the exam. So we'll be covering 4 concepts: arbitrability, which in 2 words means what kind of disputes can go to arbitration. We cannot resolve any kind of disputes by arbitration. Perhaps I shouldn't have said we are not allowed to resolve any disputes through arbitration. The second is the idea of the seat, or sometimes called the place of arbitration, which in a super simplified version means where the arbitration takes place, but as you'll see, it's a bit more complex than that, and it has certain consequences, certain implications on arbitration. The third is the concept of competence, which is the idea of who has competence to rule on the competence of the arbitral tribunal, who has the power to decide that an arbitral tribunal has the power, the competence, jurisdiction to rule on a case, to decide a case. And the fourth is the idea of separability, which the full name would be the separability of the validity of the arbitration agreements from the validity of the contract in which it is contained. So you have a contract with an arbitration clause in it, which says all disputes arising out of or in connection with this contract shall be resolved by arbitration. That's the contract, and with its clause, that arbitration clause in the contract may be valid even if the underlying contract is invalid, which is maybe surprising. You have a contract which is invalid, but one of the clauses in the contract, that one survives and is still valid. That's why that is the case. How this works is something we're going to discuss today. Okay, so that's the idea. Arbitrability. For the concept of arbitrability, I'm going to go through four main points, four main aspects of that concept. I'll first tell you what the meaning of the concept is, then why we have that concept, what the point is, what it is trying to achieve, what then it implies procedurally. If a dispute is not arbitrable, if it is beyond the scope of arbitrability, what happens? Why does it matter? And fourth, what law do we use to determine whether a dispute is of a kind that is arbitrable? What the different approaches on that question are. So the meaning of the concept, there are in fact several meanings. There is one core meaning which everyone around the world would agree on, and then there are some other notions of arbitrability, which I'm going to go to a bit later on, which are not universally shared. So this concept, the way I'm going to define it now, is the way to define it in a way which is transnationally correct, which would be correct regardless where you are in the world. And that meaning is that arbitrability defines the range of subject matters that can validly be resolved by arbitration. That's what everyone would agree on is the meaning of, I repeat, arbitrability. So certain kinds of disputes, certain subject matters can be resolved by arbitration and some not. What marks the difference? Typically, the difference, which is really very general, which should not be taken too strictly, is that economic matters can be resolved, can be decided in arbitration, and non-economic matters cannot. That's the rough fault line, the rough distinction between the two. Now, what does economic here mean exactly? As we'll see, there are many different understandings in different countries about what that exactly means. Let me start with the archetypical situation, the thing that would be considered arbitrable everywhere, respectively arbitrable nowhere. The archetype of what is arbitrable would be a dispute for liability for the breach of a sales contract. There's a sales contract, I sell you something, and I argue, you argue that it has been breached, and that raises questions of liability. This would be arbitrable in every country in the world. That's the archetype, okay? What is super typical, if you will. The archetype of what is not arbitrable, which is not arbitrable in any country of the world, would be criminal matters. So you cannot, if you murder someone, well, let's make it a bit easier. If you assault someone and the victim is still alive, the victim cannot resolve the dispute, quote unquote, it has with you, the perpetrator, in arbitration. It would not be allowed. Likewise, bless you. Likewise, the state could not allow the prosecutor to go to arbitration with you in order to resolve such a dispute in arbitration, which means privately. That would not be allowed anywhere. Non-financial family law matters are not arbitrable either, as far as I know, in any country in the world. What I mean by non-financial family law matters is what you have on the slide, deciding who is the father of a child. You cannot submit that. One may be tempted to say, this is not the concern of the state. This is a purely private concern. It is between the two people who deny that they are the father of a child, and this is none of the business of the rest of the country. This is none of the business of the state. So these disputes should be resolved between the two alleged fathers of a child and only between them, therefore in arbitration. But no, this is not allowed. I'll try to explain later why that may be the case. Child custody, if you divorce and there's a dispute over who gets to have the kids, the children, that cannot be resolved in arbitration either. Okay, but these are archetypical situations. These are super typical situations which would not be arbitrable anywhere and which would be arbitrable everywhere, respectively. Now, what exactly the fault line between economic and non-economic matters is in each country varies quite a bit. For instance, these are just a few examples here and there. Competition matters are arbitrable in the countries you have here on the slide, in Switzerland, in Germany, in France, in the USA. If you have competition or what our American friends would call antitrust matters, this can be resolved. I should not have said this is resolved. This can be resolved if the parties agree in arbitration. Intellectual property disputes in Switzerland, Germany, the US, and Japan, though typically not, as you see on the right-hand side of the slides at the bottom, the validity of IP rights are not arbitrable in France, in Austria, in Sweden. So in some countries, the validity of a patent is not arbitrable, but the breach of a license based on that patent is arbitrable, which raises complicated questions in practice if you have a dispute which is both about the validity of a license, which depends on the validity of the patent, and the validity of the patent is questioned by one party, then it has to be resolved outside of arbitration, but any dispute arising out of a license based on that patent can be resolved in arbitration. Why the validity of an IP, right, the validity of a patent is not, quote-unquote, economic enough for certain countries is points the way allows us to ask the question, allows us to see that there's more at stake than simply economic versus non-economic matters. It's a bit more complicated than that. I'll try to build on that a bit later. Employment contracts are arbitrable in Switzerland, in the Netherlands, in the USA, not in a number of other European countries. For instance, on the right-hand side, you see that individual, as opposed to collective, individual labor disputes are not arbitrable in Germany, for instance, and they're not arbitrable in Japan. So if you have a collective labor dispute that can go to arbitration between a union and an employer or a group of people representing different employers, that can go to arbitration. If it's an individual labor dispute, that cannot go to arbitration. Yes, sorry.
So does that mean if an employee was unfairly dismissed,
yes,
that then it can only be settled before the courts, they cannot be settled privately?
Correct. So the question was, if an employee was unfairly or allegedly unfairly dismissed by an employer, and there is an arbitration clause in the employment contract, and you are in Germany or Japan, that arbitration clause would not be valid. You would have to go to the courts in order to resolve such a dispute. Situations where this would be allowed is, as I have on the slide in the USA, for instance, there has been a scandal. There were arbitration clauses in contracts of Google employees in California at the headquarters. And that clause was so broad that it included even matters of sexual harassment. And there were a number of cases of sexual harassment, and the people said, I want to go to the court, I want to draw the media's attention to this. And Google said, well, I'm sorry, you cannot. There's an arbitration clause, you have to go to arbitration, and these arbitrations are confidential, so they couldn't talk about it to anyone, not even to other employees. And after a while, this leaked out, and there were a number of cases, and this was a big piece in the New York Times saying this is a way for corporations to keep scandals out of the spotlight, out of public discussions. And it was argued, understandably, I think, that this really affected the rights and the well-being of these employees who were subject to sexual harassment and who couldn't band together to stand up against the oppressors and so on and so forth. So this is what, yes? So
there was a clause that it must be in university.
Sweden.
Yes.
Mm-hmm.
Somewhere in Amsterdam it was really, really far and not really practical, and there was a huge
Yeah. So the question, for those of you in the back who may not have heard it, is it similar to the dispute involving Uber? I don't remember if I mentioned it in this course. I did, okay. The Uber arbitrations, perhaps one of the big ongoing cases involving arbitration in Switzerland has been for the last 2 or 3 years. There are indeed, or there were at least, arbitration clauses between Uber drivers and Uber the company, which is arguably, it's a complicated question, is an employment contract. Is it really an employment contract? Probably. And those disputes had to be resolved by arbitration and only by arbitration. And the arbitration was to take place in Sweden, if I'm not mistaken. And the parties could not bring their lawyers, which was considered to raise different problems. And a number of Uber drivers tried to go to the courts in Geneva and saying this is an invalid arbitration agreement. And the courts first responded, well, it's not, it is an arbitrable subject matter, as you have on the slide here. So it can, in principle, go to arbitration. But then there's this problem that it has to take place in Sweden. So a quote-unquote poor Uber driver would have to go all the way to Sweden and can bring a lawyer. And that was, a number of courts started to say this goes too far. This is a breach of fundamental rights, Article 6.1 ECHR, rights to have access to justice of Uber drivers, and therefore the arbitration clause should not be valid. Not because it's not arbitrable, but because of these additional things. You're welcome. Okay. Real estate property, if that's not commercial, if that's not economic, well, what is? Nevertheless, in Egypt and in Serbia, this is considered to be not arbitrable. Residential leases, again, this is an economic matter, but still in Germany, I don't know why I used sometimes G and sometimes D for Germany, but anyway. In Germany, this is not arbitrable. In Austria, not either. Taxation disputes are not arbitrable in France, but maybe in some other countries. Interestingly, I guess in Saudi Arabia, banking disputes with interests are not arbitrable because interests are problematic under Sharia law, and therefore this should not be, parties should not be able to circumvent Sharia law by going to arbitration and keeping the courts in the dark. This points to one of the ideas of arbitrability, that countries want to keep in control of certain subject matters. If certain countries want to impose certain values, such as prohibiting banking with interests, then private parties should not be able to circumvent this axiological value-based choice of the government by going to private dispute resolution. Going to arbitration decreases the power of a state through its courts. It decreases the power of a state to impose its own law. And I've done a study with a colleague 2 years ago about arbitrability, and what it showed is that repressive countries have very limited arbitrability. They allow very few kinds of disputes to go to arbitration. And but at the same time, some repressive regimes also have extremely broad notions of arbitrability, essentially saying anyone can go to arbitration, this serves the interests of business. But liberal democratic countries have a degree of arbitrability which is sort of median. Some disputes can go to arbitration and not others. It's really about what kind of justice you can privatize, or the justice for what kind of disputes, what kind of parts of society can be privatized. A couple more. Consumer contracts are arbitrable in Switzerland, in the USA, and in the EU. People often make that mistake when in the EU, or when they talk about EU law, they say under EU law, pre-dispute arbitration clauses in consumer contracts are not valid. So if you are a consumer and you're based in the EU, and you buy, a computer, and there's an arbitration clause in it, let's assume the seller is in the EU as well. Let's not make it complicated. And there's an arbitration clause in that contract. That arbitration clause is not valid. Or to be more specific, it cannot be held against you, the consumer. You, as a consumer, always have a choice within the EU to go to court or to go to arbitration, even if you have signed a binding arbitration agreement. So a number of people have said this means that consumer disputes are not arbitrable in the EU, which is wrong. There are ways to submit those disputes to arbitration in the EU, so long as the consumer agrees. If the consumer agrees after the dispute has arisen, or if the consumer chooses to go to arbitration in order to sue in arbitration a business, that is a valid use of that arbitration clause, which means that it is possible to send these disputes to arbitration in the EU, which means they are arbitrable, even if that comes with certain restrictions, limitations, constraints, and conditions. Interestingly, perhaps financial aspects of a divorce can be resolved by arbitration, including in Switzerland, if the financial aspects of a divorce are often the most contentious aspect of a divorce, sadly, but so it is. And these aspects can be sent to arbitration, and you can ask an arbitrator to resolve such a dispute within 3 months, 6 months, a year, whatever. And it can be tailored to make it less painful for the parties. Yes?
If a divorce is like, earlier you mentioned matters relating to, say, child custody.
Yep.
Not arbitrable. So
Correct.
if there is a divorce, does that mean that those matters will be settled?
Correct.
And
Yes, exactly. To repeat the question, I said early on, child custody matters, non-financial family law matters are not arbitrable. And now I'm saying that some aspects of a divorce are arbitrable. So what happens if you have a quote-unquote normal divorce where you have questions over child custody and financial questions? Well, it is subdivided into 2 procedures. One that goes to arbitration, which leads to a decision, hopefully, which then has res judicata, which has been decided, and the rest of the divorce is decided by a court, which can speed things up or keep separate questions separate, arguably. Okay, this is what arbitrability generally means. Then there's, sometimes you will see another understanding of another version of arbitrability which supplements, doesn't replace, but supplements, comes in addition to the notion we have just seen, subjective arbitrability. So you would find that in the number of Swiss arbitration textbooks, for instance, where people speak of the subjective arbitrability of a dispute. And what they mean by subjective arbitrability is a person's capacity to enter into an arbitration agreement. There may be situations where a person representing a company, for instance, goes what is called ultra vires, which means goes beyond the powers given to that person under the statutes of under the bylaws, I should say, in English, under the bylaws of the company. So you have a company, let me give you a concrete example. If I sign an agreement with you on behalf of the university, I say, I represent the university, all disputes arising out of the grading of the exam at the end of the year shall be resolved by arbitration. It's a dispute between you and the university, technically not between you and me, it's a dispute between you and the university. If all disputes like that have to go to arbitration, am I validly binding the university by signing this thing? And the bylaws of the university would say, no, I'm not allowed to bind the university to anything. So I have exceeded my powers, I have gone ultra vires. Therefore, people who use this concept of subjective arbitrability would say, I do not have legal capacity to enter into this arbitration agreement, therefore the dispute is not subjectively arbitrable. Now that I have mentioned the concept, I would recommend that you do not use it, that you forget it. It's just for you to understand what it means if you come across it in the case law and in the Swiss textbooks. Forget it because there's an easier concept for that, which is legal capacity. Legal capacity means exactly that. Legal capacity determines when one person is able to enter into a contract and when not. There is no need to make up a new concept which speaks of subjective arbitrability. So it's a concept for which there is already something else in the legal system, which is legal capacity, so it should be forgotten, I think. Another final version of arbitrability, what it may mean for certain people, that's a concept used in North America, in the USA, and in Canada, which means that a given dispute at a given time can go to arbitration. Which means, for instance, we are in a sales contract, we have a dispute resolution clause, and the dispute resolution clause says we first have to, if there's a dispute in the contract, we first have to go to mediation for 3 months, and only after 3 months can we go to arbitration? Then we have a dispute, and I try to go straight to arbitration, not respecting that clause which says I have to wait, I have to go to mediation for 3 months with you. That dispute, technically, we would say it's not admissible yet. It's not ready to be resolved in arbitration. The arbitrators would say, I'm sorry, I cannot hear that dispute just yet. You have to go to mediation for 3 months and then come back to me. In the rest of the world, we would call that a problem of admissibility of a dispute. In the USA and in Canada, they say the dispute is not arbitrable just yet. It will be arbitrable in 3 months, which is a very different understanding of what arbitrability means, because it has nothing to do with the kind of dispute. It's simply about the question whether a dispute is ripe for being resolved in arbitration, whether all the legal conditions are fulfilled at that point in time for it to go to arbitration. Okay. I'm mentioning this because if you read legal scholarship from North American arbitration scholars, they will use case law, they will use that notion of arbitrability, which again is very different than what it means in the rest of the world. Okay, so why do we have arbitrability? I've mentioned it in passing. Let me talk about it straightforwardly. The answer is fairly simple. Some matters should be resolved in public official courts, not by some private individuals behind closed doors. That's the idea, that arbitrators are private individuals resolving disputes behind closed doors, and certain disputes are too important socially, axiologically, which means relating to the values of a country, for instance. They are too important for the repercussions they may have on the reputation of people, on how we want as a society to deal with certain people, certain situations, that they should not be resolved by just some quote-unquote random individuals who can do that in a confidential manner. Certain subject matters are too socially important to be entrusted to a mechanism that is almost entirely cut off from the democratic system, or indeed from state control. As a democracy, we have far less control over what happens in arbitration than we have over what happens in court. Whether that's good or bad is a complex notion, but what most people agree on is certain subject matters should remain within the control of the state and the government, and therefore the people that the government is meant to represent. What these subject matters are varies from one country to another, as the earlier list should have made clear, hopefully. That in certain countries, for instance, the validity of a patent is something which should be decided publicly in court. Questions of criminal law are too important for society to be decided by private people behind closed doors. There should be a public aspect of it, and it should be resolved by people who have been elected or chosen as judges, not people who are chosen by private parties, people who are chosen by society. Yes, please.
Reading stated that in a lot of Muslim countries, criminal matters are subject to arbitration.
Second, in Muslim countries, what is?
Criminal matters are subject to arbitration in some Muslim countries.
This is, I haven't seen that I haven't reread the readings. This sounds actually sounds wrong. I would actually doubt that it's correct in Muslim countries that criminal matters can be resolved by arbitration. Not in the modern forms, not today at least, but... okay, fair enough. It's... I have never ever come across a criminal law matter resolved in arbitration, but there may be cases where I may be wrong, and the reading may be correct. Let's put a question mark next to it. It's certainly extremely unusual internationally. I should check my readings before I give them to you. Fair enough. Yeah. Okay. Procedural implications of arbitrability. If something is not arbitrable, what does that mean? It means it cannot be resolved by arbitration in any way, regardless how the parties agree, regardless how much the parties want it, regardless how everyone, the parties, the experts, the witnesses, the victims, the perpetrators, the arbiters, how much they want it. No arbitration about an inarbitrable subject matter will be valid. It cannot be decided by arbitrators at all. So So it's beyond it's beyond contractual freedom. Arbitrability is not something which can be altered, changed by the freedom of the parties. If the parties say we want to make this arbitrable, they cannot. Okay. What law do we apply to determine whether a subject matter is arbitrable? To do that, you have to go to look at different phases in an arbitration. First, let's look at arbitral tribunals. When a subject matter is, you start an arbitration, and you tell the arbitrators, we'd like to resolve dispute X, we'd like you to resolve dispute X. What law will that arbitral tribunal apply? In principle, the law of the seat of the arbitration, the law of the place of arbitration. I'm aware we haven't discussed the notion of the seat, that will come later, but by and large, the law of the place where an arbitration takes place. The law of the potential place of enforcement has not been given much weight, even though some people say it should be. The idea is, there's a big case going on right now in Singapore between a major Indian corporation and another party. I don't recall where it is based. The arbitration takes place in Singapore. The Indian party keeps telling the arbitral tribunal, you should take the notion of arbitrability in the country of enforcement, you should take it into account, which is Indian law, because it is the only place where this arbitral award is likely to be enforced. And it is not, that's a subject matter, which is not arbitrable in India. Therefore, the entire arbitration would be for naught, would be for nothing, because it would lead to an arbitral award which can only be enforced in India, and in India it will not be enforced because it is not arbitrable there. So arbitrators should take into account the law of the place where the effects of the arbitral award will likely materialize. There hasn't been a decision on that just yet. This arbitral tribunal is still constituted. This is really an exception. In principle, you do not know where an arbitral tribunal is likely to be enforced. So there's little reason to take into account the place of enforcement later on into deciding whether a dispute can be resolved by arbitration or not. Sometimes, as the slide suggests, the lex contractus, the law applicable to the contracts, has been applied and is said that it should apply to determine the arbitrability of a notion. So the idea is you have an arbitration based with a seat in Singapore over a sales contract, and the sales contract contains a choice of law clause which says that sales contract is governed by English law. Okay. So you have an arbitration seated in Singapore applying English law to determine whether the contract was breached or not. And the question is, should the notion of arbitrability under English law be applied to determine whether the dispute can be resolved by arbitration or not? The arguments to say that, yes, please. You ask an interesting question about the law that governs the validity of the arbitration agreement, which indeed may be different than the law that governs the validity of the rest of the contract, which is one possible implication of the notion of separability. So why would one apply the law that governs the contract to determine arbitrability if in reality we should apply the law that governs the validity of the arbitration agreement to it? In practice, people tend to make a difference between, I don't want to make it too complicated, the law that governs the validity of the arbitration agreements, the law that governs the validity of the contract, that governs the contract, and arbitrability. That you can apply three different laws to that situation, theoretically at least. Whether it's a good idea is a different question. The argument in favor of the lex contractus, without going into the notion of questions of coherence between the different laws which we just discussed, that applying the lex contractus, so the lex contractus is about the party's substantive rights. Our sales contract is subject to English law. English law will determine our substantive rights, the rights we have under that contract, how the contract is going to be interpreted. So some people say if the lex contractus determines our substantive rights, it should also determine the way in which these substantive rights are determined, established, interpreted, which is arbitration. So the notion of arbitrability of the lex contractus should be taken into account. The argument against that is to say the lex arbitri, the law of the seat of arbitration, is the only correct law to apply to arbitrability, because the lex arbitrability is the law of the place where the arbitration takes place. And therefore that country should determine what kind of disputes can be resolved privately and what kind of disputes can be resolved publicly in court. Therefore that's the law that should determine arbitrability. This is the law of the place of arbitration, which should determine what kind of justice, private or public, takes place for what kind of disputes on the territory of that state. Yes, please.
If, for instance, a tribunal should decide that, let's take the case of the arbitration pending in Singapore, and the tribunal owns that this is Indian law to be applicable to the matter of arbitrability, but the subject matter is not applicable under Singaporean law, wouldn't the court in Singapore annul the award and so on?
We're going to come to that it's on the next slide actually. The question was about what happens if the arbitrators apply quote unquote the wrong law to arbitrability. I'll explain that. What happens subsequently? I'll come to that in a minute. Okay, I just wanted to leave that choice, to make you conscious of that choice, that some people are saying we should apply another law to arbitrability. Some people even say we should apply all three laws. We should apply arbitrability under the law of the seat, plus arbitrability under the law of enforcement, plus arbitrability under the lex contractus. And a dispute should only go to arbitration if it fulfills the criteria of all three laws. That's what some arbitrators say. An important point is what happens once the arbitral award has been rendered. Then it may go to annulment proceedings, which will take place necessarily in the law of the seat. So you have an arbitral award which says either this dispute is not arbitrable, end of the arbitration, or this dispute is arbitrable, and we continue with the arbitration. After that, the losing party challenges the award in court, which will be the courts of the seat of the arbitration, and the courts of the seat of the arbitration will apply their own notion of arbitrability always. They will always say, we apply the lex fori, we apply the law of our country. Swiss courts would apply the Swiss understanding of arbitrability. Singaporean courts would apply the Singaporean notion of arbitrability to say whether that dispute should have gone to arbitration or not, and therefore whether the award shall be annulled or not. Which, this was the question that was asked a minute ago, if an arbitrator says, well, yes, the law of the seat where we are says this dispute is not arbitrable, but the law of enforcement says it is arbitrable, for instance, then I'm going to go ahead anyway, and I'm going to arbitrate over this dispute, and this then goes to annulment, and the courts of annulments are almost certainly going to annul this arbitral award. So the whole arbitration was arguably for nothing. So it's pragmatically, instead of relying on considerations like this, what is logically the best notion of arbitrability to apply to a dispute? We can look at it pragmatically and say, well, what happens if we apply a certain law to determine arbitrability? What happens in subsequent, later court procedures? Which, by the way, as a general statement, is an interesting approach to law to say, as opposed to say, what should be logically coherent as a legal solution, and what is likely to happen in practice if we do X or if we do Y. Without veering off too much, you probably have heard, those of you who have done legal history, the German pandectists in the 19th century were all about legal consistency, and it's all about trying to build up law as a mathematical system where everything would logically hang together, which then has led to the American realist, which said law has to be something in the real world, coherence and consistency is taken far too seriously. What is important is what's the effects of the law in practice. Whether there's a contradiction in law is really not so important. You still find traces in this. In the case law of the Swiss Federal Tribunal, you find traces of this in scholarship, where some people are obsessed about coherence, consistency between two different legal solutions, and others say we have to look at the consequences in practice on actual people, actual situations. And you find that in the teaching of law professors as well, where some people are all about, let's try to build a system which is, in theory, nice and free of contradictions, and others who have a more sociological bent say, we have to look at the actual consequence in practice of this. This law faculty is not so much into legal sociology, generally speaking. Some colleagues are, but most of them tend to be on the other side, trying to find coherence in the law as opposed to what it actually does in practice. The courts of enforcement, if I end with my footnotes, the courts of enforcement, the place where the award will be enforced against the assets of the losing party, for instance, will always apply their own lex fori, will always apply their own law. So if you have an arbitration over which is seated in Switzerland, in Geneva, and the dispute is about banking with interests, no problem of arbitrability there, then you try to enforce such an arbitral award against the assets on the bank accounts of a party in Saudi Arabia. The courts in Saudi Arabia will say, sorry, we can't enforce. You cannot enforce that here. We will not recognize or enforce that arbitral award here. And that obviously varies between one country and another, which also points to the important notion which I said early on. Concretely, what happens in such a situation if you want to enforce the award against assets in Saudi Arabia, it's not recognized and enforceable there, well, you have to go after assets located in other countries, or you have to wait until the assets move, until money is transferred from one bank account to another bank account in another country, and then you go for enforcement, you go after that money elsewhere. Okay, I have 2.5 minutes left. Let me just start with the notion of the seats of the arbitration. I'll cover 4 points. The meaning of what does the seat of an arbitration mean? What are its procedural implications? What its procedural implications are not? And then something a bit more pragmatic, empirical, how the notion of the seat has led to a competition of different countries to attract more arbitrations, to be better arbitration seats, and how that has shaped the law of arbitration. There's a current development in Germany. Germany has been trying to resolve, to renovate, to amend, to renovate its arbitration law with the express purpose of attracting more arbitration business to Germany. People who would be a bit cynical would say this is one way, one attempt to make German lawyers, arbitration lawyers, richer, to give them more cases. We'll discuss that later. Briefly, last thing before the break, what does the seat mean? The seat, which is synonymous with place of an arbitration, is something like the place of incorporation of an arbitration. It is its geographical place of reference. It is the country whose law it has the closest connection to. The seat would designate a city, not a country, designate a city, and arbitration would sit in Geneva, Zurich, or London, Stockholm, Kuala Lumpur, and so on and so forth. The seat is in principle chosen by the parties. If you ever come across an arbitration agreement, if you have a client coming to you and says, I have this arbitration agreement, should I sign it or not? You should not sign it if your client should not sign it if there is no seat specified in the contract, in the arbitration agreement, because it will lead to problems later. And the parties can and should choose the seat of an arbitration. And typically they do that in the arbitration agreements. They can also do that later on, but later on they most likely won't agree. And if they don't agree, the arbitration institution will set the seat somewhere for the parties. And if the institution doesn't do it, or if it's ad hoc arbitration and there is no institution, the arbitrators will do it, will determine where the arbitration legally takes place. Okay, what that concretely means in practice is something we'll see after the break, when we'll talk about the procedural implications of this. Thank you very much. See you after the break.
There is a mistake with the...
With the QR code? No.
Yeah, you need to go down. The QR. Yeah, you need to... I have changed it. If you can reload the... reopen it.
It just has, no?
That's new. Let me see. I don't remember.
But
probably just passed you. Yeah,
no. Okay.
Yeah, no. I have answered, so it's correct.
It's correct?
Yes, it's correct.
It also says JLDS, the code on your...
Yeah, I have just answered it.
But it's...
So it's correct.
Thank you.
Yeah, that's the thing that they are dealing with exceptional cases, and another one is anyway enforced.
The convenience was to apply the South Korean version, saying perhaps you won't be able to enforce it. There are many able to enforce it. The Indian government says, obviously, of course, you have to render the enforcement of the side. Whereas if you do render the awards, in this particular you are contravening your duty to reflection.
I don't know.
But anyway, the problem is like, I mean, if I were to okay, I have to render an enforceable award, but still, we wouldn't get to that stage.
We wouldn't get this.
To the stage of enforcement, in the end, I'm playing on there and say, okay, in the end, the arbitration applied to the law of India. I have to convert. So, it's like, okay, in principle,
No, it's not.
Okay, let's get back to it. Perhaps there's been a couple of questions. I haven't been very clear, I think. This point here, for instance, the parties choose the seat, ideally, if there is an arbitration clause which says all disputes arising out of this contract shall be settled by arbitration under the rules of the ICC, and the seat shall be in Paris. Then everything's fine. That's a fairly good, not perfect, but fairly good arbitration clause. If you have an arbitration clause which says all disputes arising out of this contract shall be settled by arbitration under the rules of the ICC, stops there. No seat has been determined. It is not because an institution has been chosen that a seat has been chosen. It is not because you want your dispute to be resolved under the rules of the ICC, which is based in Paris, that you set the seat in Paris. Choosing an institution does not choose the seat, does not set the seat somewhere. Okay? So in this case, you will have a situation where the parties can't agree. Let's assume they have not agreed in the arbitration agreements, and later on, as the arbitration starts, they still can't agree. Then the institution, in my hypothetical, it will be the ICC, will say, okay, let's set the seat somewhere. It may be Paris, but it may be an entirely different city. If the two parties are one in Malaysia and the other in Japan, it is unlikely that the seat will be in Paris. I hope this makes some kind of sense. I may have misled you with this when I said place of incorporation, which may have pointed you to say, well, the ICC is something like a corporation, so it must be the place of the corporation. That's not what I meant. By place of incorporation, which is why I put it into between inverted commas, what I meant is to say you can have a company, nothing to do with arbitration, a company incorporated here in Geneva, and in reality, nothing much happens in Geneva, but it has certain legal implications. What I'm trying to say with this is, what I'm going to expound on a bit later, is the fact that an arbitration can have its seat in Geneva and no one ever comes to Geneva. The parties never set foot to Geneva, in Geneva. And yet it has certain procedural implications. To clarify that, let me simply continue, which is come from this, what the procedural implications are and what they are not. So the procedural implications of setting the seat somewhere is that they determine the lex arbitri. The lex arbitri, Latin for the law of the arbitration, is the law that governs an arbitration, the law that will tell you, I think I have it later on. Yeah. The law that governs an arbitration, the law that says what the procedural rights of the parties are, where you go to the courts in order to seek annulment of an arbitral award, and so on and so forth. That's the lex arbitri. So, for instance, an arbitration with seat in Geneva or Lucerne or Zurich, whatever, anywhere in Switzerland, the consequence is that Swiss law is the lex arbitri, which concretely means that Chapter 12 of PILA applies to this arbitration. Okay. Now, what does that mean in practice? What does it mean if we say Swiss law applies to an arbitration? Which means the question, what matters in a lex arbitri? What would you find in a lex arbitri? We have gone through that together during, I think, the second week, when I walked you through the provisions of the Swiss arbitration law. To recall or to recap what is really important in a lex arbitri is things like the rules on the validity of an arbitration agreement. By and large, at least formal rules, whatever. If you apply Swiss law, you will know if the arbitration agreement is valid or not. If the seat is in Paris of an arbitration, you can conclude an arbitration agreement orally. You don't need something in writing. In the new German law, which if it is enacted, which it's pending, if it is enacted, that will be possible in Germany as well. In Switzerland, this would not be possible. An arbitration agreement has to be in writing. That is, determines where, in the lex arbitri, when do you apply the lex arbitri if the seat is in that country. What else? The basic procedural rights that the parties have is determined by the lex arbitri. If the seat is in somewhere in Switzerland, in Geneva, for instance, Swiss arbitration law, as the lex arbitri applies, and tells you whether the parties have the right to be treated equally, the right to impartial and independent arbitration, the right to an oral hearing, the right to rebut one's opponent's case, the right to be heard, and of course, more specifically, what does the right to be heard mean in this country or that country, and so on and so forth. Okay. Third thing, formalities of the award, less important, but well, it does matter. If the seat of an arbitration is in Switzerland, Swiss law applies. It will tell you if the award has to be in writing, if it has to be on actual paper, or if it can be electronic, if the arbitrators have to come together to that place in order to sign it, and so on and so forth. And finally, default procedural rules. If you have an ad hoc arbitration without an institution, you don't have many rules to tell you how the arbitration is to be conducted. So where would you find these rules? In the lex arbitri. The lex arbitri will give you a default procedure which the institutional rules would typically opt out of. But if there are no institutional rules, or if they are silent on a given point, then you apply the procedural rules of the lex arbitri. Okay? So if you choose the seat somewhere in the negotiation of the arbitration agreement, these are some of the implications of setting the seat somewhere. There are others. Let me continue. The second implication of the choice of the seat is that it determines where you can challenge the arbitral award. To put this differently, you can have, if you want to try to have an arbitral award set aside, annulled, quashed, which is synonyms for the same thing, you can only do that before the courts of the country of the seat. The lex arbitri will tell you which courts exactly in that country will be relevant. So if you have an arbitration seated in Geneva, you look to Swiss arbitration law, which tells you before which courts you can seek annulment of such an arbitral award. Okay. If it is an arbitration based in Lyon, the French arbitration law will tell you which courts in France you have to go to. But it has to be courts in France, and if the seat is in Switzerland, it has to be courts somewhere in Switzerland. What these courts are and how many there are, here's a chart which compares them in, let me start with the simplest situation. Here in Switzerland, every annulment proceedings would go to the Swiss Federal Tribunal, to the Federal Supreme Court, Tribunal Fédéral. You go straight to the Federal Tribunal, and once you get a decision from the Federal Tribunal, that's the end of the story. You cannot appeal that. under certain exceptional circumstances, you can try to go to the European Court of Human Rights, but that's, as a matter of principle, it should be forgotten. So there's only one instance of annulment in Switzerland. In Russia, to take another country in which you have only one judicial instance, only one level of court which can deal with annulments, you would go to the court of first instance. If the arbitration is based in Moscow, it would be the Moscow arbitrage, I think it's pronounced, the Moscow arbitrage court. If it's elsewhere in Russia, it would be a different court. But there's only one court, and the decision of that court you cannot appeal. As the slide suggests, no appeal on merits. For some serious procedural flaws, you can try to appeal that court decision. Just to be clear, when the slide here says no appeal on merits, what I mean by that is there's no appeal of the court decision on merits. I'm not speaking of appeals of the awards on merits. Okay, we'll talk about annulments procedures. You can almost never appeal an arbitral awards on merits. You can, in some countries, appeal a court decision on merits, even if the court decision deals with an arbitral award. In France, you have two rounds, two judicial instances, the Court of Appeal, the Cour d'appel, and then the Cour de cassation. And the Cassation Court, the Cour de cassation, reviews only points of law, doesn't go into mistakes that the Court of Appeal may have made with regard to the facts relating to the arbitral award. In England, you have a so-called 2+ system where you go to the High Court, then to the Court of Appeal with leave. What leave means in the British system is that the higher court needs to give you leave to appeal. You ask for the permission to appeal, and the higher court gives you leave or not, which is up to the court to decide. It's within the discretion of the court to allow you to appeal it or not, to appeal from a lower court. And in some situations, you can go one step further up to the UK Supreme Court. That is only possible if it relates to major points of law, if it's likely to lead to a change in case law or something really fundamental. It's extremely rare. And again, you need leave of the UK Supreme Court. So in practice, it's typically 2 rounds of annulments, and exceptionally you can go up to the UK Supreme Court, which is why we call it a 2+ system. In Singapore, it's two tiers, High Court and Court of Appeal, which renders final decisions. You cannot appeal decisions of the Court of Appeal in Singapore if it relates to an arbitral award. And in the Netherlands, it's the Court of Appeal, the Gerechtshof, if I pronounce that correctly, and then you go up to the Supreme Court, the Hoge Raad, if I pronounce it correctly again. It used to be, that has changed 10 years ago, 2015. Before that, there were 3 levels of annulment procedures. You would go to the district courts, and then to the Court of Appeal, and then to the Supreme Court. To give you a sense of how this matters in practice, the largest arbitration ever, the so-called Yukos arbitration, where the former shareholders of a major oil company called Yukos in Russia sued Russia for expropriation of the company, essentially. Give me just a minute. So that arbitration starts in 2005. In 2014, 9 years later, the arbitral tribunal renders a decision awarding the former shareholders of Yukos an award for $50 billion, the largest arbitral award ever, 50 USD billion. Same year, 2014, there's a request for annulments. The seat of the arbitration was in The Hague. So the first annulment goes to the district court in The Hague. 2 years later, 2016, there's an annulment by the district court. Immediately appealed by the party who lost that appeal, which is the shareholders. The shareholders had all of a sudden seen their $50 billion gone. So they appealed that decision to the Amsterdam Court of Appeal, which overturns the district court's decision. They reinstated the award. They said, shareholders, you have your $50 billion back. Then Russia appealed that decision to the Dutch Supreme Court, which is where it is still hanging now. The Dutch Attorney General just a few months ago made it clear that the court should reject the appeal and leave the award be. With interests, because awards are typically rendered with interests, UCOS, or the former shareholders of UCOS, now have a claim of approximately 65 billion against Russia. So the arbitration starts in 2005. 20 years later, today, we are still dealing with that arbitration because of 3 tiers of annulment proceedings. My point in telling you that story is to say, if arbitration is meant to be sort of expedited justice, faster justice than courts, if you have 3 levels of annulments in a country, this defeats the purpose of speed and cost. By the way, in this UCOS arbitration, so 65 billion to be enforced against Russia, enforcement proceedings have begun because annulment procedures don't freeze the possibility of going for enforcement. And so far, over the last 20 years, 500 million of the 65 billion, 500 million has been collected. Russia, more specifically Sergei Lavrov, the Russian foreign minister, has threatened retaliation against any country that would allow the enforcement of arbitral awards against Russian assets. So it's unlikely that the UCOS former shareholders will get much more money, which is the reality of arbitration. You get a huge award, 50 billion plus interest, 65 billion, and in reality, you recoup 500 million, 750 million if you're lucky, and you will have spent easily, for such a big arbitration, 20 million in lawyers' fees. So is it that good an investment? I'm not sure. Yeah, well, if you invest 20 million and you get 600 million, it's not such a bad investment, but over 20 years. And this is considered to be a success story in arbitration. All of that to say that if you choose a seat somewhere, you have different levels and you have different courts and different numbers of levels of courts. And the more you have, the more quality control you have over the arbitration, but the longer it takes and the more costly these annulment proceedings are likely to be. Also, it is important to know where the seat is, to set the seat in a particular place, because not only do you have more or fewer courts which deal with annulments, but the grounds of annulment will be different. The reasons for which you can obtain annulments are different. In some countries, the award will be more insulated against annulment. In some countries, that is to say, it is extremely difficult to annul an arbitral award. In others, it is simpler. If you set the seat in Switzerland or in France, it will be very, very difficult to annul the arbitral award. If you set it in Germany, at least until the new law, it was easier to have it annulled. There's more quality control by the states over an arbitration than there is in sort of Switzerland and France. Also, and that is, I suppose may sound silly, but it's real, the judges of certain countries are more knowledgeable about arbitration than in other countries. If you set the seat in, I'm going to pick one example at random, in Uganda, I do know that the Ugandan judges don't know much about arbitration because there aren't many arbitrations taking place there. So the likelihood that there's a judicial mistake is far greater if you set the seat in, say, London, where judges deal with arbitration, perhaps not every day, but very regularly. Some countries have, and the judges in some countries are less versed, less used to dealing with arbitrations. For a long time, this has changed now, but 20 years ago, China was some not Beijing, but other cities in China were a major problem. The judges there didn't know arbitration, didn't like arbitration, and annulled cases by misapplying the Chinese arbitration law. And this left parties dismayed to say, well, that's not what the law says. But the judges said, yeah, but I'm going to annul the award anyway. So what can you do then? Not much. This has completely changed. China is now a leading house in arbitration. But it remains the case that in some countries, judges are more competent in arbitration than others. Third implication of the seat, the so-called juge d'appui. Even in English, we speak of the juge d'appui. The juge d'appui is the courts at the seat which will assist an arbitration, which will help an arbitration take place. Not exercise control over an arbitration, but help it take place. What does that mean? The juge d'appui, the courts of the seat, will appoint an arbitrator if there is if the parties were not able to choose one, and I should add, if the institution doesn't appoint an arbitrator. So the courts of the seat, in this case, it's the courts of the seat locally, the city. If you have an arbitration seated in Geneva, and you can't agree on an arbitrator, the institution won't appoint one for whatever reason, or it's an ad hoc arbitration, there is no institution. In such a case, you turn to the court in Geneva to appoint an arbitrator. Removing an arbitrator, challenging an arbitrator, again, if it is not done by an institution, the courts of the seats may do that. You may have to turn to the courts in Geneva to say, arbitrator X has a conflict of interest. She or he is to be removed. The local courts will do that. Ordering provisional measures, ordering the freezing of bank accounts, seizing evidence, things like that, can be ordered by the courts of the seat. And again, some courts are more diligent than others. If you set an arbitration in a, so to speak, remote country, in a remote city, it's where the courts are slower, this may not be the best choice for an actual arbitration. Remote countries in the sense of countries which are not used to dealing with many arbitrations. Fourth implication of setting the seats, somewhere the nationality of the awards. An arbitral tribunal seated in Geneva rendering an award, that award will be a Swiss award. Why does that matter? Not because it's Swiss quality award, but it has an impact on enforcement, has an impact on, with regard to the New York Convention. Why? Remember, I said this in passing, I'll say it again here, the New York Convention state allows states to enter a reservation. In public international law, if a country becomes a member of a convention, of a treaty, it can enter a reservation. It can say, we will apply this treaty except for certain provisions. At least if the treaty allows that. And the New York Convention does allow that. And it says, contracting states may declare to apply the convention only to awards made in the territory of, which means have the nationality of, another contracting state. Remember your public international law classes, some conventions are applicable erga omnes, with regard to applicable to any other country, and some conventions are applicable only on the conditions of reciprocity. I apply the convention to your country if you are a member of the convention, and only then. Okay? The New York Convention allows member states to do one or the other, depending on whether they enter the reservation or not. Half of the New York member states conventions have entered the reservation and have said, I only apply the New York Convention to arbitral awards rendered, made in, which have the nationality of another New York Convention member state. And the other half of the New York Convention member states have said, we apply the New York Convention to any foreign award, regardless where they come from. So if you set a seat in a non-New York Convention member states, enforcement will be difficult in half of the New York Convention member states. Because all of these countries will say, we won't apply the New York Convention to you because that award comes from a non-New York Convention member state. Okay? And that is determined by the seats. What the procedural implications of setting the seats somewhere are not, where the hearings are held. If an arbitration has its seat in Geneva, it does not mean that the parties have to come to Geneva to hold hearings here. They can hold hearings in London. They can hold hearings in cyberspace, online, and never have any physical meeting in one place. Where the hearings take place is what in arbitration language we call the venue. The venue is where the hearings actually take place. And there may be several venues and several different venues in arbitration. You can have a first hearing in Kuala Lumpur, a second in Beijing, and a third somewhere in the Philippines. That's entirely possible. It has no implications on an arbitration whatsoever. The parties and the arbitrators can choose to have the hearings wherever they want. Here is a recap of that. The seat of the arbitration, the seat of the arbitral tribunal, the place of arbitration are all synonyms. They all mean the same thing. It's about what I call the place of incorporation of an arbitration. It is where it is legally taking place. And there can be only one place. There can only be one seat for an arbitration. Why does that matter? Why does that matter? That's what we've seen early on. It triggers the applicability of the place's national arbitration law, the lex arbitri. It has a number of other consequences, which I'm not going to go into. On the other side, this side for you, the venue of the arbitration is where the hearings are actually held. And there can be multiple venues, multiple successive places where the parties meet for hearings. And this has no legal consequences on an arbitration. Okay. Now, empirically, practically, if the correspondence between the two is in the rate of 70 to 80%, if the seat is in Paris, 70 to 80% of arbitrations seated in Paris do take place. The venue is in Paris as well. But there's no legal connection between the two, it just happens to be the case. Okay. There's some caveats about that. The first is holding the hearings outside the seat of the arbitration is a principle which is almost unanimously recognized, not unanimously. There are some countries, I wouldn't venture to name some countries which are less supportive of arbitration, let's put it this way, which say arbitrations seated here have to take place here. It's a very small minority of countries, but you should be aware of it. And if you set the seat somewhere, do check whether, and if you want to have the venue elsewhere, do check what the law of the seats actually says. And the second is what I mentioned already. There are statistical indications suggesting that if you set the seat somewhere, it is statistically likely that the hearings, the venue will eventually take place there. So if you absolutely want to avoid Paris because it's too far away, it may not be the best idea to set the seat in Paris. If you have an arbitration between a party in Malaysia and one in the Philippines, it's probably not a good idea to set the seat in Paris. It is to be expected that the arbitration will take place in Paris. Why? Because the parties would have to agree on a different venue. And if they don't agree, the arbitrators are most likely going to say, let's do it at the seat. It's just by default, it's so there. It's a practical thing to be kept in mind. And have seen arbitrations seated in Tel Aviv, and then the question was, should we travel to Tel Aviv during the war? Perhaps or perhaps not. So it may have implications which the parties may want to avoid. Okay, let me turn to a practical implication on the arbitration industry. That's the end of the black letter law lecture for today. Mostly, I think. The competition among states to be better seats to attract arbitrations. In the past, well, I shouldn't say in the past, it's still the case that countries try to have as many arbitrations take place in that country. Meaning mostly that the venue is there, but as I said, statistically it's correlated to the seat. So arbitrations try to have as many, states try to have as many arbitrations seated in their own country. As I said, Germany revised its arbitration law so as to have more arbitrations seated in Germany. Why is that a good idea? Because if, assuming that the seat is the same thing as the venue, which as I said is 70 to 80% of the cases pragmatically, empirically correct, and if the venue means the use of hotels and other business and possibly local lawyers, this means more business for that country. To put it simply, Germany is trying to boost its economy a little bit by having more arbitrations in Germany. Switzerland did that 40 years ago. France has been doing that constantly over the last 30 years. London has been doing that aggressively again a couple of years ago, changing the arbitration law so as to have more arbitrations in London, respectively, Paris, respectively, Geneva, Zurich, and now Berlin and Cologne and other German cities. If you are an arbitration seat, if you're a country which is an arbitration seat and you want to attract more arbitrations, what do? Typically, you try to make the arbitration as simple as possible. You are as supportive of arbitrations as possible, which means that you exercise less control over arbitration. So far, so good. What does that mean? If states are competing to attract business and they try to attract business by deregulating, what happens? You have what is called a race to the bottom. It's a bit like competition for taxes. If each country decreases tax a little bit to attract business, then on the whole, there'll be less taxation in the entire world. Depending on your political inclination, you may think this is good or bad, but what this means is less money collectively in public coffers. What this means for arbitration is there's less and less control by states over arbitrations. Is it a good idea or a bad idea is a complex notion which we may discuss a bit when we'll talk about the privatization of justice. Is it a good idea to privatize justice? Justice is being privatized ever more. There's ever more deregulation, less public regulation over arbitration globally, which helps globalization, but which has other problems. By and large, it makes countries richer, but it makes them more difficult to govern. Sorry, I lied. It's not the end of the black letter law part of today's class. One last concept. Oh, there are two more, sorry. Competence. So competence, what does that legal notion mean? It means the competence of a tribunal to rule on its own competence, on its own jurisdiction, on its own power to decide a case. It's not actually an arbitration-specific concept, the concept you find in public international law about the ICJ, ITLOS, International Tribunal for the Law of the Sea, and other courts which have the power to say that they have jurisdiction to deal with the matter. It does apply in arbitration where an arbitral tribunal has the power to rule on its own jurisdiction. An arbitral tribunal has the power to say the arbitration agreement is valid and therefore I have jurisdiction, or to say the arbitration agreement is not valid, I do not have jurisdiction. To be a bit more specific, competence has two dimensions, a positive and a negative dimension, which is not a qualitative judgment, means something else. The positive effect of competence means that, what I just said, an arbitrator has the power to rule on its own jurisdiction. You don't have to go to a court to say, arbitrator, do the arbitrators have the jurisdiction to decide this case? You go straight to the arbitrators to ask whether they have jurisdiction to deal with this case. Okay? What that implies is the negative effects of competence, which is that if you go to the courts for instance, in Geneva, and say, there is an arbitration clause in my contract, but I think it is invalid. What the court is going to do is, if there's an arbitration agreement, you have to ask the arbitral tribunal whether it is valid or not us. Courts will send the parties back to arbitration if there is an arbitration agreement in the contract which appears prima facie to be valid. If it is obviously not valid, then you can go to court. If you have an arbitration agreement which says all disputes arising out of this contract shall be settled by the International Chamber of Commerce in Geneva, which does not exist, is that a valid arbitration agreement or not? Not clear. You go to the courts in Geneva, in Paris, in London, and say, we believe this is an invalid arbitration agreement, so allow us to go to court. The courts will say, this is off our hands, we have to go to arbitration and let arbitrators exercise competence to decide whether that arbitration agreement is valid or not. And only if they say it's invalid can you come back to us. You find that in Swiss law, for instance, in Articles 7 and 186.1. Different countries are more aggressive in that stance. In France, for instance, sends the parties back to arbitration almost always. In England, you have better chances, if you see it as a chance, or more risk, that a party goes to court and says, it's pretty obvious that this arbitration agreement is invalid, so do deal with this case. And last concept, separability, the separability of the arbitration agreement from the contract in which it is contained. The validity of the arbitration agreement can be separated from the validity of the underlying contract, of the main contract. Why do we need that in arbitration? Because otherwise, if you go to arbitration to say the contract is invalid, Let's assume the arbitral tribunal says, yeah, indeed, the contract is not valid because it is against public policy, because it is an illegal contract, because there was duress, whatever. If it says the contract is invalid, and if that would imply that the arbitration agreement is invalid as well, then the arbitral tribunal, by saying the contract is invalid, would remove its own jurisdiction to say the contract is invalid because it comes to the conclusion that the clause which allows it to say the contract is invalid, that clause is invalid as well, so it doesn't have the power to say the contract is invalid. This appears in a path of logic, so to speak. The way this is laid down in arbitration laws is, for instance, in the Swiss law, the arbitration agreement cannot be contested on the grounds that the main contract is not valid, which may lead arbitral tribunals to actually apply a different law to the validity of the arbitration agreements than to the validity of the contract. It may interpret that law differently. It may assess facts differently. It leads to a number of complicated questions. The point for you to remember today is simply that it is not because a contract is invalid that the arbitration agreement contained in it is invalid as well, was void or voidable as well. Okay, let's, if you agree, play a bit. What I'm offering to you to do is, if you scan this QR code, it should take you to an in-class quiz, which should show you exam-type questions. I'm going to do it as well. And if it does work, please do answer the questions, and I'll show you the results in a minute, and then we'll discuss the results in the minutes we have left. Yes. Thank you. Oh, did everyone? Yeah, apparently. Thanks so much. Thanks for having prepared that, by the way. I have many thumbs up. Let's see what it does. What are you thinking? I'm nodding. Okay, then we can push it over when they are done. Okay, cool. Okay, perfect. Did you see it? No. Do you have time to discuss? Oh, this week or today? It's going. But that doesn't need me to read the pages that I have sent you. Because I want to see if I have back concepts correctly. Can we do it tomorrow? Okay. Because I have a lunch appointment and I'm teaching from 2 to 4 and I have to rush off. Okay. Tomorrow. Or send me your conclusions now. I send you the what I want you to read through that whole discussion and then don't read what I. Okay. Two pages and I want to do all the time. Sorry, we can. It's too late. Anytime. Okay, you tell. I'm free. Okay, let's discuss it first. Okay, this is. These are the aggregated results, or this is what you have answered. We are sorry. So I'm going to simply to go through this with use of arbitrability concerns the jurisdiction of the arbitral tribunal. The answer, well, you all got that one right. The 17 people who answered apparently did. So it is correct. It does concern the jurisdiction of the arbitral tribunal. It concerns what a state considers to be part of its public policy, its fundamental legal values. Yep, indeed. Most of you got that, almost everyone got that right. It concerns what exactly the parties wish to submit to arbitration. No, that you got that one, I'm afraid. Those who answered yes got that one wrong. It's not what's the part. No, if it's green, it's that they answered correctly. Sorry? If it's green, it's that they answered yes.
No, that doesn't play a role.
Say again?
It doesn't play a role.
It doesn't play a role. Okay. So the answer to what exactly the parties wish to submit to arbitration is no. Arbitrability has no relationship with what the parties want. The parties may want to submit something to arbitration. If the dispute is not arbitrable, they cannot do that. Arbitrability tells you nothing about what the parties want, and it is disconnected from party autonomy, disconnected from what the parties want. Okay? So the answer should have been no. Nothing of the above should have been answered no as well. Without the competence principle, the efficiency of the arbitration would be jeopardized. 83% of people said yes. Indeed, that is the idea, and that is the correct answer. Without competence, you would have, for each arbitration, you would have to go to the courts to ask the courts for an interpretation of the arbitration agreement for a decision on whether it is valid or not, and then only go to arbitration. Which means you'd find yourself in court for a couple of years, possibly, and only then can you actually start the arbitration. So competence is indeed there to facilitate the efficiency of arbitration. So the correct answer is yes. Competence, positive effect, empowers an arbitral tribunal to render an award declaring its lack of jurisdiction. The answer is, again, yes. It gives the power to the arbitrators to do whatever they want to do, whatever they think is right to do, including saying, actually, we don't have jurisdiction over this case. We have the jurisdiction to say that we don't have jurisdiction. We have the power to say, we cannot decide with this case. So the answer to the second to last question should have been yes. The last question, the parties can avoid issues of inarbitrability by wisely choosing the seat of the arbitration. You all got that right. Yes, indeed. That's how if you have a concern about, there's one more? There's a couple more, okay. You can, if you want to avoid problems of arbitrability, choose the seat wisely because the seat determines in principle arbitrability. Okay. By wisely choosing the place of enforcement of their awards, you can, that's a tricky question. I'm not sure we should use, probably we haven't used that question for the exam because it can be interpreted in different ways. In principle, the answer is, we have not, okay. So that's the sort of question that is good for discussion, but would be too open-ended for an exam. Well, first of all, can you really choose the place of enforcement? Well, let's assume there are assets in different places. If you choose a place where there are assets and where the issue is arbitrable, then indeed you can circumvent problems of arbitrability at the stage of enforcement. You may have problems of arbitrability at the stage of enforcement, in addition to problems of arbitrability during the arbitration. Am I making sense? You have an arbitration over a sales contract for alcoholic beverages, takes place in Switzerland. You don't have any arbitrability problems. You want to enforce it in Saudi Arabia, you will have an arbitrability problem there. So you're going to go after assets located in France, for instance, and by doing that, you avoid problems of arbitrability at the enforcement stage. If you're concerned that the question is too open-ended, again, we haven't used that in an exam. The questions in the exam will be more specific, will be less subject to different interpretations. And last question, by designating other procedural rules as applicable that override the law of the seat. No, you cannot override the law of the seat with regard to arbitrability. You can opt out of a large number of issues, questions, rules in an arbitration, but not the rules on arbitrability. Arbitrability is beyond the party's control. It is not part of party autonomy. Okay. You cannot opt for certain procedural rules by choosing an arbitration institution, for instance, to alter anything regarding arbitrability? You have 1 minute for questions if you want about these questions or about anything else. Yes, please. Arbitrability does concern, yes, the answer is correct. It does concern the jurisdiction of the arbitral tribunal. It also concerns what a state considers to be part of its public policy. Yes. Yes, absolutely. And it's the two first ones are correct, yeah. Sure. Yes.
There's a debate in theory whether arbitrability falls within the public policy. State law is an autonomous thing that focuses only on jurisdiction, but it relates to both. Yeah, so it's a matter of personal. So in the example, would be one answer.
The point about what Dimitris just mentioned about the connection between arbitrability and public policy, we have not seen in class. Don't worry, it's a more advanced question. Yeah, we don't have time for that discussion today, but it's an interesting one. Okay, doke. I hope you're not too concerned about these questions. If you didn't perform too well today, it does not mean that you should be concerned about the exam. The questions are clearer, more straightforward, and you will have more time to prepare, of course. Thank you so much, and see you next week. Thank you.